Hello students, I hope your exam went very well. Yesterday I gave you list of exceptional topics. From list of exceptional topics many questions came and I'll tell you those questions. So in this video I'll explain you the suggested answers for CA Inter May 2025 Paper 2 Corporate and Other Laws. I gave you a list on April 18th. So this is what you prepared 7 chapters from zero and you can expect at least 60 marks from these 7 chapters I told you. And if you observe carefully, 65 marks came from these 7 chapters. LLP 14 marks, General Clause Act 8 marks, FEMA 14 marks, Deposits 5 marks, Charges 15 marks, Foreign Company 9 marks. Okay, let's look into the question paper without wasting much time. So this is objective paper ma. First I will read the MCQs. Mr. Praveen has approached you to seek guidance for how many members he can accord his confirmation to act as proxy. Maximum a single person, proxy can represent 50 persons or 10% of the paid up share capital or members holding maximum 10% of the paid up share capital according to this rule. So C is the correct option. Mr. Praveen can accord his confirmation to act as proxy for 50 members, 52 wrong, 50 if they are holding in aggregate not more than 10% of share capital of the company carrying voting rights. C is the correct option. Mr. Rajan, a member of the company entitled to vote at a meeting of the company shall be entitled to inspect the proxies. What is the time limit for inspection of proxies? 24 hours before commencement of the meeting. For deposit of proxy, 48 hours before commencement of meeting. Whereas for inspection of proxy forms, 24 hours before commencement of the meeting. And it ends with the conclusion of the meeting. So option A is correct answer. As a company secretary of the company, advised board of directors to reply to the question raised by a member in the meeting. So regarding prescribed period for which company shall preserve register of members permanently. Copies of documents, annual returns filed with ROC 8 years. So option C is correct answer. Register of members permanently and copy of documents to be preserved for up to 8 years. Annual returns also up to 8 years. Copies of annual returns filed with ROC. Getting my point? Copy of documents filed with ROC up to 8 years. Next one, case scenario 2. First we'll look into the questions. If at all needed, I'll read scenario. Barossa Insurance Company Limited has issued certain instruments which among the following shall not be covered under the definition of securities. Securities excludes unit linked insurance plan. Straight away, unit linked insurance plan, it combines the benefit of risk and premium. Risk is covered, reward is also covered. So unit linked insurance policy will not come under the definition of securities. Exceptional topic this is. Yes, I didn't cover it. In marathon, I told about this point. In marathon, I covered 100 marks, 100% came from marathon only. For sure. Classical Diagnostics Limited proposed for variation in the shareholders' voting right. How much percentage of issued shares of the class shall be required for the consent of passing such resolution? This point I covered in exceptional topics. 3/4 of the value. 3/4 of the value I told you. 3/4 means 75% of the issued shares of that class. So option D is the correct answer. Next one. Where the holders of at least of issued shares of a class who did not consent to the in favor of resolution of variation. Dissenting shareholders can file a petition with tribunal, but they should possess at least 10% of the class capital. 10%. Option B is the correct answer. Case 3 MCQs, yes, FEMA. For his show in Canada, he needs to obtain approval for remittance of foreign exchange from, maybe it's a cultural tour. Yeah, cultural tour. Department of Education and Culture. Option D is the correct answer. Mr. Ronak Moshe has inquired from you that for which of the following purposes is he allowed to draw foreign exchange? Own travel to Nepal. Under LRS Schedule 3, this is prohibited. Schedule 3 current account transactions, Nepal, Bhutan prohibited. 50,000 out of lottery winnings, prohibited current account transaction. Sweep 6, prohibited current account transaction. Gift, yes. Gift to the brother in Canada allowed. Option D is correct answer. Mr. Ronak Mose desires to remit $150,000 for payment of prize money to the winning team in a cricket tournament in Canada. Mr. Ronak neither international sports body nor state sports body nor national sports body. So he is not covered under exceptions. And here amount exceeding $100,000. $100,000. So definitely he need to take prior approval of central government. And the prior approval of central government is here, Ministry of Human Resources Development, Department of Youth Affairs and Sports. Option D is correct answer. Clear? Prize money for winning team cricket tournament. This is not, lottery. This is not lottery. So option D is the correct answer. Next, 10th question. As per LLP Act, the term resident in India means person who has stayed in India for a period of 120 days. 120 days during the financial year. 120 days, option A. As per LLP Act 2008, whether above LLP fulfills the requirements of designated partners, at least one designated partner should be resident in India, ma. At least one designated partner should be resident in India. No, as both partners Rohita and Anushka should be resident. Both need not be resident in India. At least one should be resident in India. No, as both should be non-resident. This condition is also not there. Yes, Rohit is a resident of India as defined under LLP Act. So let's see. Rohit got an opportunity to provide. Let's see. Rohit and Anushka, after passing out CA examination, incorporated an LLP to work as a practicing chartered accountant. Rohit got an opportunity to provide consultancy services as an ongoing basis to a company based in Singapore. Rohit remained in India only for 90 days during the financial year 23-24. The LLP continues its operations. So Rohit can be designated partner, but he is a non-resident, first of all. LLP continues its operations from India with Anushka, whereas Rohit participates in decision making remotely. Based on the facts, tell me the answer. Okay, as per LLP Act, whether above LLP fulfills the requirements? Yes, LLP fulfills the requirements. One partner is a resident in India. One designated partner resident in India. So option D is correct answer. Option D is correct answer. No wrong answer, no wrong answer. Yes, here, Rohit is resident in India. Wrong answer because his period of stay is 90 days. But for us, what is the requirement? 120 days. So option D is the correct answer. Next, 12th one. The term year as per General Clauses Act means financial era. No, it's a British calendar year which starts from January to December. Option B is the correct answer. General Clauses Act 1897 was enacted on 11th March 1897 to consolidate and extend General Clauses Act. Yes, 1868 General Clauses Act, 1887 General Clauses Act. Next one. Jade Suits LLC is a chain of hotels and restaurants all over the world. It is proposing to establish a hotel at Goa. It has appointed a chartered accountant, Mr. B, for taking care of registration formalities of the company. Okay, so this is a foreign company. First of all, it is very clear. While the registration process was going on, company entered into the lease agreement. Until registration is over, how can it enter into the lease agreement? Okay. After a few months, directors of Jade Suits LLC withdraw their consent with their interest in establishing a hotel at Goa due to news in social media regarding fall in tourism industry. The landowner refused to pay advance received by him. Can Jade Suits LLC, in the capacity of foreign company, can sue landowner? Until registration gets over, until registration of foreign company gets over, it is incapable to sue third parties. It can't sue third parties. However, outsiders can sue foreign company. So based on this, the registration process is not yet complete. Hence, Jade Suits LLC cannot sue the landowner in its capacity of a foreign company. Getting my point, students? Yes. So this is wrong because registration not yet over. So registration not yet complete. So it cannot sue landowner in the capacity as a foreign company. Next, last MCQ. Any instrument in the form of depository receipt created by domestic depository in India. Domestic depository in India means definitely it's IDR. And authorized by the company incorporated outside India, making an issue of such depository receipts is called Indian depository receipt. This is also MCQ from foreign companies. Clear? Global depository receipt means it's a depository receipt created by overseas depository, authorized by company incorporated in India. So not a global depository receipt, it's a Indian depository receipt. With this MCQs over. Next one, coming to the descriptive. First question, first question is tough. Tough means it's not actually tough. Unanticipated question, unexpected question, because the first question is all about, subscribers to the MOA. If subscriber is illiterate person, 2 foreign nationals, 1 LLP, 1 private limited, then how they will subscribe MOA? If you observe carefully, in my material, that point was summarized in half page. Of course, I covered it in marathon. I didn't cover it in exceptional topics. I covered it in marathon. So this is the answer for that question. 5 marks, first question. After looking at first question, psychologically many students will not feel good. But okay, fine. Only 5 marks only. Only 5 marks, but I'm sure those who have read these 5 points, signing of MOA, OA, illiterate subscriber, next one, body corporate as subscriber, foreign national as subscriber. If you have read these points, you can easily write this answer. Next one, Sangeeta was appointed as statutory auditor of ABC Limited in AGM of the shareholders held on 20th August 2023. However, Sangeeta met with an accident on 23rd December and died. Board of Directors of ABC Limited filled a casual vacancy. Yes, this is a casual vacancy other than resignation. So, Board of Directors are having authority to fill the casual vacancy. The next AGM of the company was scheduled for 28th August 2024, in which Board of Directors recommended for appointment of Ashish as statutory auditor before the shareholders. Keshav objected the appointment of Ashish and gave representation to the company secretary, stating that appointment was approved by Board of Directors after the death of Sangeeta. Thus, can continue as statutory auditor of the company till the conclusion of next 6th AGM, and also threatened to report the matter to ROC and NCLT. Exactly wrong, ma. Because any auditor who got appointed in the place of casual vacancy, that auditor tenure comes to an end by the conclusion of upcoming AGM. So, the contention of this fellow is not correct. So, explain the procedure to fill the casual vacancy of the office of the statutory auditor. Board resolution is sufficient. But if it is a casual vacancy due to resignation, then board resolution plus members approval within 3 months. Within 3 months of board recommendation, members should ratify it. Whether the contention raised by Keshav justified? No. What shall be the answer if casual vacancy in the office of statutory auditor was caused by the resignation? Yes, board resolution plus members resolution. That means ordinary resolution. Members approval is required. Easy question only. Easy question. Mr. V is a person of Indian origin who has moved to USA along with wife in the year 1998 and has been living until 2024. He was holding joint bank accounts with his wife in USA since 1998. On the death of wife, 17 November 2024, he returned permanently to India on 24th November 2024. He also inherited wife money after death, who got transferred to bank account in USA. After a few days of his return to India, he has paid premium from the bank account in USA insurance policy, which he had taken when he was in USA. Referring to the provisions of Foreign Exchange Management Act, examine Mr. V is permitted to carry out about the transactions. Of course, yes. This is the exceptional topic. Last point video and I discussed the same point. A non-resident during his when he was non-resident acquired any properties. Subsequently, he became resident. Of course, he can continue to hold such properties. He can continue to carry such transactions. There is no problem. This is the exceptional point. Yesterday, I discussed with you. Next. Of course, yes is the correct answer. Deposits, deposits. This is also there in my exceptional topics. Very clearly, I told all those 18 points. Deposits points I covered with respect to promoters' contribution. I don't know how many of you remember. With respect to, yes, just look at this point, promoter loans. I didn't erase it. Promoter loan, that point is also there. Let me read the point. IQ Books Limited received share application money 50 crores from investors on 8th December 2024. As the issue was undersubscribed, company refunded the amount to the investors on 20th February 2025. Now you need to check whether refund was made within 75 days or not. Within 60 days, allotment should be done. Within 60 days, allotment should be done. So in December, 31 minus 8, how many days? 23 days. And in January, 31 days. So total how many days, Mark? 23 plus 31? 54 plus 6. By 6th February, they need to make allotment. Or else refund within 15 days from 6th February. So since refund was made within the time limit, it's not a deposit. If refund was made after 15 days, from the expiry of 60 days, then it becomes a deposit. Same point I covered here. Application money, just look at this point. Application money pending for allotment up to 60 days. If not refunded within 15 days, then it becomes deposit. I wrote here also. Super point, ma. Next one. Suraj Raj Tejas are promoters of Precious Jewelers Limited. They borrowed a sum of 200 crores from ABC Bank Limited for its working capital purpose. The bank imposed a stipulation that promoters should contribute at least 20% of amount borrowed. Hence, Suraj brought 10 crores. Raj brought 15 crores. Mr. K's father of Tejas brought 15 crores. Directors, relatives of the directors giving money. Promoters giving loans because of stipulation imposed by the lending financial institutions are not treated as deposits. This point also I covered. Promoter loans. Next one. Pretty Cosmetics Limited issued non-convertible debentures and listed on a recognized stock exchange. Just look at this point. Debentures point of view, I told you. Secure debenture, not a deposit. Convertible, not a deposit. Listed, not a deposit. If you observe carefully, listed on recognized stock exchange, not a deposit. So 5 marks deposits came from exceptional topics. This 4 marks also came from exceptional topics only. And let's go on. I'm really satisfied with the paper, ma. Next, question B. Spark Services Limited issued a prospectus inviting public offer of securities as on 18 June 2024. Prospectus mentioned Mr. T is one of the directors of the company. Mr. T is a famous social worker who helps in educating poor children. Okay. Mr. C was impressed by the statements and subscribed the shares of the company. He was allotted 1000 shares of the company. He subsequently sold 250 shares to Mr. D. So therefore, two parties are involved, Mr. C, Mr. D. So Mr. C acquired 1000 shares and already sold 250 shares. So 750 shares are pending. He came to know that T was not the director and company never had intention of doing community service. That means this is misleading in nature. This is a misstatement. This is a misstatement. Let me show you in exceptional topics. Prospectus. Here I gave you 1 point, misstatement cases. If you observe carefully, director's friends have subscribed larger portion of the capital. It was a misleading in nature. Based on this point only question came. And in misstatements also, effect of punishment, effect of misstatements, punishment point of view, I clearly told you this point also. If a person gave consent and he withdraw the consent before issue of the prospectus, public notice, and if you observe carefully, immaterial reasonable grounds. Here I told you a point that based on the faith of the prospectus, if you subscribe shares in a primary market, then only you can claim civil liability, you can claim compensation under civil liability, or else no. So accordingly, C can claim compensation with respect to 750 shares. D, who purchased shares from open market, not primary market. In secondary market, he acquired shares. Therefore, no benefit to D. C can claim compensation provided C should suffer loss. If C is not suffering with any loss, then C can't claim compensation. Getting my point, students? But C can resign the contract. C is having right to resign the contract. D cannot. Not only D, but also subscribers to MOA cannot resign the contract. Next one. So this one also, this 5 marks also came from exceptional topics only. Purva by Buildcon Limited is a public company having two subsidiary companies, namely ACL and SBL. Purva is the CFO of PBL. Ashish and Rinal, who are CFO of ACL and SBL, resigned from their respective company. Purva was offered to take charge of these two companies, which she accepted. Now the question is about, in General Clauses Act, whether singular includes plural or not. For one subsidiary, you can, if you are appointed, for one company, if you are appointed as CFO, yes, subsidiary is covered under exception. Now subsidiary, singular includes plural or not? That is the point here. Masculine gender includes female, singular includes plural. That is the point, ma. Easy question. Next one, third question. I don't know how many of you listen my exceptional topics in prospectus. Just look at this area. Export statements, conditions for inclusion of export statement. This point I told you, and this point came in the examination. So disclosures to be made on the face of the prospectus. Copy of prospectus has been filed with ROC. Export statement, underwriting commission, like these agreements. What are all the agreements filed with ROC along with prospectus? Disclosure is required. Condition to include export statement, as you all know. Date of publication of prospectus. It's nothing but date on which prospectus offered to the public. Publication of prospectus means prospectus given to the public. So on or before date of publication of prospectus, a copy has to be filed with ROC. Super, fantastic. Next, Vital Pharmacy Limited is engaged in manufacturing of medicines to cure skin diseases. It has established a unit in Germany. It registered few patents in Germany. Intangible asset. Patent is an intangible asset. Created outside India. Okay. Company registered. By creating a charge on its stock in Germany and also patent rights. Charge was created on inventory as well as patent rights. Where the patent rights were located, patent rights were outside India. Next one, company received a notice from ROC for not filing the particulars of the charge created by the company on the property assets situated outside India. And company defend the notice on the ground that it shall not be the duty of the company to register particulars of the charge created on the patents. Yes, exactly. The contention of the company is wrong. Why? The reason is, yes, patent should be whether intangible asset or tangible asset located outside India or inside India. If charge is created, that charge should be registered with ROC. Next one, this question also covered in exceptional topic. When floating charge gets converted into fixed charge. I covered this point, ma. Crystallization of floating charge. Next one, NOSITA or ASOSIS, direct question. Accounting software, this is also exceptional topic. Of course, I didn't cover. With respect to audit trail, edit log requirements, backup of the books of accounts, daily backup is required. Audit trail should be enabled. Edit log should also be enabled every time. That is the direct question. Next one, Sun Roofings LLP has 6 partners. So let me see the requirements. Referring to the provisions of LLP, state whether Mr. K share can be used to repay the firm's debts after his death. Retiring partner's share cannot be used for payment of firm's debts. Retiring partner's share should be returned to the deceased partner's legal heirs. The remaining partners of Sun Roofing Repeats can prohibit M to take part of the business. In the question, they clearly told that one partner, he assigned his interest in favor of third party, outsider. Now, can third party participate in the management activities? No. Of course, remaining partners can prohibit that assignee from taking part into the business. So, this is also nice question. Illustrations cannot modify the language used in the ACTMA. So, they can explain the provision better, but they had no power. They had no power to modify the language. Write down the functions and duties of NFRA. One more direct question, unexpected question actually. Functions and duties of NFRA. In exceptional topics, I told you the company is governed by NFRA, but here functions and duties of NFRA was given. Next one, 5 points distinction between LLP and limited liability company. Exactly. Revise 45 marks in 4 hours. One video I uploaded day before yesterday. Last point of LLP video, I told you. Please read differences between LLP and partnership, LLP and company. One question came for 5 marks. Direct question, but unexpected question. Next one, Dream Builders Limited was engaged in the activity of building, selling budget-friendly apartments. Okay. It recently started a new project, Noida. Pending approval, the builder started construction work. On verification of the documents, refusal to sanction permission. Mr. S issued a demolition order. Okay. So now the point, in this question, the point is all about power to issue orders by a functionary. Includes his successors also, or his ordinates, subordinates. If Mr. ROC, whatever task Mr. ROC can do, assistant ROC, deputy ROC can do the task. So same point I covered in the marathon as well as topics, exceptional topics. So the builder filed an appeal and stayed the demolition. After 6 months of the court trial, verdict announced in the favor of Corporation of Noida. Mr. G, the present assistant commissioner, initiated demolition process. Assistant, not main commissioner, assistant. Builders argued that order passed by Mr. S, since he is no longer in the authority, order stands cancelled. G cannot demolish. No. Subordinates, in the absence of main officer, subordinates can do the things. Last question, DNC Hydro Limited obtained a loan of 3,000 crores from SMP Bank, Hydro Power Generation Unit. This is all about charge document, charges. So charges. Now the point is, here they forgot to register, in September 2024, fully repaid the loan and issued no due certificate. But due to internal complaints oversight, company failed to file CHG4. Satisfaction of charge was not filed. So now what are the remedies available? Of course, ROC is having own powers. ROC is having suo motu powers to register the satisfaction of charge and issue memorandum of satisfaction of charge. This is also a direct question. Next one. ABC Incorporation, a company based in USA, develops cyber security software and sells it to Indian clients. Place of business is in India. ABC Incorporation, therefore it's a foreign company. But the point is, PQR Private Limited, an Indian company, Indian body corporate, holds 50% shares of ABC Incorporation. So for rule, 50% is sufficient. 50% is sufficient to consider it as a deemed Indian company. Deemed Indian company. Let me show you in foreign company. First, straight away I told you 50% is enough. 50% is enough. Straight away, easy question. Whether ABC Limited is required to comply with the provisions of chapter 2, not only chapter 22, but all other provisions also, they need to comply. Next one. Define foreign exchange, foreign security. Simple topic. Definitions: foreign exchange definition, foreign security definition. That's it. So overall, from exceptional topics, 30 plus marks came. If I'm not sure, but 35 plus marks came from exceptional topics. And I wish you all the very best for your taxation exam.